Good evening and welcome. My name is Kim England. I am a professor of geography, the Harry Bridges Endowed Chair, and the director of the Harry Bridges Center for Labor Studies at the University of Washington in Seattle, where it's actually snowing. Thank you for joining the Harry Bridges Center this evening as we celebrate the release of a new book, Union by Law, Filipino American Labor Activists, Rights, Radicalism, and Racial Capitalism. Let me tell you a little bit about the Harry Bridges Center for Labor Studies at the University of Washington. The Bridges Center was founded in 1992 by members of the International Longshore and Warehouse Union in memory of their longtime president, the very remarkable Harry Bridges. Our mission is to advance the study of labor and working people in higher education through teaching, research, and community outreach. The ILWU's longstanding commitment to pragmatic organizing, principled anti-racism, democratic unionism, and social justice continues to serve as the touchstone for our mission. I welcome you to learn more about our program and our many upcoming events at our website, labor.uw.edu. As you will see tonight, Union by Law is the product of a long-term relationship between the Harry Bridges Center, our faculty, our friends in the labor movement. We are proud to count the book's authors among the Bridges Center's former directors, and very importantly, to count the activists who will be joining us this evening as our friends and collaborators. Before we begin, I would like to thank our many event sponsors. The Labor Archives of Washington, which is located in the UW libraries, departments from the UW, including Law, Societies and Justice and Political Science, and also WISER, the Washington Institute for the Study of Inequality and Race. I also wish to thank the Greater Seattle chapter of the Filipino Historical Society, Seattle's LELO, Legacy of Equality, Leadership and Organizing, the Pacific Northwest Labor Association, and APALA, the Asian Pacific American Labor Alliance, AFL-CIO. It's always that last bit that catches me there, sorry. I am now so happy to introduce our first speakers of the evening, the authors of Union by Law. Professor George Lovell is the Divisional Dean of Social Sciences and a Professor of Political Science at the University of Washington. He served as the Harry Bridges Endowed Chair from 2012 to 2014. His research explores how American law influences the way people respond to injustice and organize for political power. His successor at the Bridges Center was Michael McCann, the Gordon Harabashi Professor for the Advancement of Citizenship. Professor McCann ended his term as the Bridges Center Director in 2018. He is a longtime scholar of the politics of rights-based struggles for social justice with an emphasis on challenges to race, gender, and class hierarchies. And here I want to do a shout out to both of them because they have made my job as the current Bridges Director so much better. So thank you both. And now please join me in welcoming Michael McCann.
Thanks very much, Kim. Hello, everybody out there. Good afternoon, good evening, good morning, depending on where you are around the world. I want to thank everybody for taking time out to join us for this book launch. It's very humbling to know that we have well over 200 people who registered, and hopefully a large number of those people are actually out there listening right now. I'm sorry to tear you away from the so exciting impeachment hearings covered on TV, but maybe that would be a point to talk about a little bit later about what our book has to do with understanding the Trump phenomena, but that's getting ahead of ourselves. I want to begin by expressing my gratitude to the people who made this book launch possible. In the book itself, we outline a lot of gratitude that we have for many people who made the book possible, and I'm not going to acknowledge those individuals now, but a lot of them I know are listening. But I want to thank the people who make the book launch possible. First of all, it's the Bridges Center, Kim England, Andrew Hedden, Yasmin Ahmed, and others in the center. I want to thank the other centers and departments on the University of Washington campus who are co-sponsors. I want to thank the panelists who I will be introducing at the end of my remarks and those of Professor Lovell. And then finally, I want to thank George Lovell himself, who is the co-author. You may hear or may have heard from Professor Lovell that his contributions to the book have been limited. And let me make clear that that's not the case. George was important in imagining this whole book project and developing the research and undertaking the research and designing the actual write-up of the book and actually doing some of the writing. And unfortunately, because he's such a good administrator, he couldn't continue at the same pace that he began, but he's been a very important part of it. And I'm very glad made the whole project this much better for me. And probably made it a better, I'm sure it made it a better project altogether. Okay, so it's a little bit difficult to figure out what to say about a book that took 25 years to develop and is nearly 500 pages long, and I do that in about 12 or 13 minutes. So I thought what I would do is do what's often done at a book launch, which is just read from the book. And I've chosen to do that to begin at the very beginning of the book, because I think it outlines a statement about the goals of the book and where the book goes, as well as I could do without reading from the text itself. So let me begin with the opening lines of the book. The book begins with a quote from Supreme Court Justice Harry Blackmun, who is a dissenter in the case of Wards Cove packing Atonio in 1989. This is what he says. It says, the salmon industry as described by this record takes us back to a kind of overt and institutionalized discrimination we have not dealt with in years. A total residential and work environment organized on principles of racial stratification and segregation, which, as Justice Stevens already pointed out, resembles a plantation economy. This industry long has been characterized by a taste for discrimination of the old-fashioned sort, a preference for hiring non-whites to fill its lowest level positions on the condition that they stay there. The majority's legal rulings essentially immunize those practices from attack under a Title VII disparate impact analysis. One wonders whether the majority still believes that race discrimination, or more accurately, race discrimination against non-whites, is a problem in our society, or even remembers that it ever was. Justice Blackmun's strident protests underscore deep divisions on the US Supreme Court in a class action civil rights case initiated by Filipino American and Native plaintiffs against an Alaska salmon cannery during the 1970s. The 5-justice majority, led by Justice Byron R. White, rejected the workers' claims regarding pervasive invidious discrimination in the cannery, and in the process issued a landmark ruling that significantly increased the obstacles for all plaintiffs seeking judicial remedies for institutionalized racism. Blackmun and his fellow dissenters charged the white majority with ignoring both key factual evidence presented by the plaintiffs and important legal precedents that had made the 1964 Civil Rights Act a potent resource for aggrieved non-white and female workers. The most provocative claim by Blackmun, however, turned to a speculation that the majority of justices failed to remember, or perhaps willfully ignored, not just legal precedents, but a long, dark, continuing history of legally enforced racial and class domination in America. The allegation of legal forgetting and immunization against challenge evokes the classic argument of legal scholar Robert Cover about the fundamental ways that official law kills off challenges to status quo hierarchies and systematically diverts attention from its violence, thus erasing both legal rights claims and their authoritative rejection. Indeed, a later chapter will elaborate on how Justice White's majority opinion relied on fanciful hypothetical scenarios, legal abstractions, elevation of procedural over substantive justice, and racial stereotypes to discount the material facts of institutionalized practice that long had exploited minority workers. That erasure has been compounded by mainstream legal scholars who routinely, if unwittingly, validate as binding law the majority ruling that systematically privileged white business interests without acknowledging the many decades of abuse that led racialized working class plaintiffs to file the lawsuit in the first place. The Supreme Court's emphatic authorization of racial and class hierarchy at work, as well as its embrace of neoliberal economic rationalization, was so routine that it generated only modest critical commentary in the mainstream mass media and in scholarly publications. In the process, a history of struggles for egalitarian rights in global justice by minority, race, and female workers over the previous 2 decades, and more generally for over hundreds of years, has been nearly expunged from the conventions of official legal knowledge. A willful posture of what James Baldwin called racial innocence, the endemic cultural crime, infused the highest law of the land. And that's a core argument of our book. The study that follows in the book is the first effort to situate the infamous Wards Cove case in the broader social and legal history of racialized workers' struggles for social justice that culminated in the lawsuit. Organized as a chronological narrative that spans most of the 20th century, the account begins with the bloody US invasion of the Philippines, an extension of oppressive colonial rule at the dawn of the 20th century. The chronicle then follows the migration of proletarianized Filipino workers to the US metropole, where they were conscripted for seasonal work as wage laborers in the West Coast agricultural fields and Alaska salmon canneries, then formed a series of unions to represent their interests and advance their social reform goals, and then, led by a younger generation of activists, struggled persistently for class, race, and gender-based social justice throughout the Cold War political context of national security, state development, and global empire building. As we presented, official American law was repressive in 3 senses. First, in upholding systematic exploitation of Filipino workers, productive labor, and marginal racial status over many decades. Second, in repressing the labor activists' relentless campaigns challenging capitalism, racism, and imperialism. And third, in the Wards Cove opinion, continuing a long tradition of erasing those interrelated histories. As such, our analytical narrative is very much intended to be an act of recovery, a reclamation of a long legacy of violent racial capitalist domination over Filipinos and other low-wage or unpaid migrant workers. Reclamation of noble aspirational struggles for human rights by the workers over several generations. And in many ways that law was mobilized both to enforce and to challenge race, class, and gender hierarchy at work. Okay, so that's the first few pages of the book. As the introduction suggests, the focus of our book in many ways is on the contradictory power of law and how it works in American history. We emphasize that law is contradictory and that it's both an institutional mechanism for enforcing as well as contesting and challenging those hierarchies and exclusions. It's a book about contestation on the terrain of law. We've already noted that the book's organized as a historical narrative, beginning with the invasion of the US Philippines and in the dawn of the 20th century, and ending with the civil trials to identify the murders of Cindy Domingo and Jean Viernes, as well as the Supreme Court ruling in Wards Cove, the Atonio. Along the way, we covered lots of history of American capitalism, history of race relations, history of union development and union building, and empire building. But it's not just a historical narrative. The rendering is grounded in a number of analytical and theoretical innovations. The core theoretical framework of the book is grounded in what socio-legal scholars call legal mobilization theory. Legal mobilization simply points to the mobilization of legal rights or legal entitlements to challenge existing relationships, especially existing hierarchical or injurious relationships. Legal mobilization studies are very common in the field that we work in. Both Professor Lovell and I have written previous books working out of the legal mobilization framework. One of the, I think, not completely novel, but somewhat novel aspects of what we do, we also integrate critical race theory, trying to develop a systematic structural understanding about how race plays out in American society into the legal mobilization framework to underline the difficulties and challenges of struggling to challenge racial hierarchy and exclusion. So that's the general theoretical framework. But there's other innovations, I think, and this is the more intellectual part, which I'll try and be fairly brief about. One of those is that most studies of legal mobilization take the form of classic social science case studies. They take cases that are relatively limited in the spatial scope, the time, and the number of issues that are addressed. They take place in particular times and places that are fairly circumscribed. But our study is really quite different. It's different in that the temporal scope is much greater. We are looking at struggles for social justice over nearly a 100-year period. So we see not just a single episode or a limited number of episodes of legal mobilization struggles, but scores and scores of episodes of legal mobilization. Secondly, the spatial scope is quite expansive. We look at various places in the migratory patterns of migrant workers as they are in their lives from the late 19th through the 20th century. That takes us to various geographic sites, including starting with the Philippines, and then to California, and then to Washington State, then to Alaska, and even to Hawaii, so that the struggles that we are documenting take place over a long period of time and in lots of places. And one of our challenges is to try and show the continuity and the connections among those different kinds of struggles and the purposes of those struggles. And then also the different kinds of issues over which Filipino Americans were fighting. Many of those regarded the conditions, wages, safety, et cetera, the workplaces, but they concerned a whole lot of other issues. The Filipino Americas were taking on a whole variety of issues to try and challenge the pillars of racial hierarchy. A second innovation, I think, besides research design, is three basic kind of concepts to make sense of the story that we tell. The first of these has to do with the general historical context, and that is the institutional ideological context of what we call racial capitalism. The book agrees with many legal scholars that law is inherently violent, but the book underlines a specific targeting, both instrumental and structural violence in the service of racial and class domination. The core insight of racial capitalist theory is that racism and capitalism are not separate or even just intersectional vectors of hierarchical domination, but rather historically interdependent and mutually constitutive structural forces. Specifically, if capitalism expands through the accumulation through dispossession and surplus value extracted from workers, race marks those workers who are likely to be wageless as slaves or indentured servants or women in household production, or those forced into the lowest levels of work with the lowest wages, fewest opportunities for advancement, often attended by harsh, unsafe working conditions and segregated living spaces. Racialized workers, in other words, are either tend to be rightsless or nearly rightsless, either unfree or semi-free by the terms of mainstream American society. Cannery workers in both generations were very explicit about challenging those mutually constitutive terms of both racial and capitalist domination, rather than dealing with one versus the other, as often is the case in contemporary debates about social justice. The second theoretical dimension of what we're trying to do builds on the understanding about racial capitalism, which is to suggest that the American legal order has never been homogeneously and consistently a liberal constitutional order, as often is said. Instead, America has always experienced a plurality of legal orders. Certainly, there has been a liberal tradition of granting rights and protections for mostly white property owners, but there's also been a variety of other legal orders which have treated other differently situated people differently. Think about slave law, Black codes, Asian exclusion laws, immigration law, laws dealing with the status of aliens, laws dealing with the poor and the homeless. Those are all different legal orders that are targeted to specific populations which grant different kinds of legal treatment, often more violent, more arbitrary than the kind of treatment, the due process and rights respect that is accorded to white property owners. So our legal system does become more uniform after World War II. That's the moment when we often talk about the triumph of liberal constitutionalism. But we argue that forms of what we call repressive or authoritarian or illiberal law from the earlier period continue to subjugate workers of color and other disposable populations, even after World War II. America's always been a land where some mostly white property owners are full rights-bearing members of the legal community, and others are semi-free or unfree, rightsless to various degrees. What we try to argue is that these different forms of legal ordering targeting subaltern people, targeting them in ways that subject them to greater domination and violence and oppression and harsh conditions, continue on, especially in forms of criminalization of subaltern subjects, of immigrants, of poor people, and the like. But one of the things that's also distinctive is the sort of wrapping those forms of traditional repressive law in the sort of cloak of liberal proceduralism. The due process provides the sort of appearance of liberal constitutional rights protection, even while sustaining those forms of repressive law targeted at poor people, people of color, women, immigrants, and the like. Now, this isn't just a sort of academic point. It has implications for how we think about political and legal struggle. The classic legal mobilization theory has always posited that legal mobilization for social justice takes place between the promises of the liberal legal order and those people that are not included in it. But we look at it a little bit differently. It's not between those who are in the liberal legal order and protected by it and those who are left out. It's really a clash between different legal orders. The legal order of slavery, the legal order of the Black Codes, the legal order of Asian exclusion versus liberalism. And that sort of raises the stakes and complicates the struggles for extending rights and providing the sort of liberal guarantees for populations that are subjected to those forms of repressive law. Finally, and it is finally, we're through the book, we're also trying to rethink what we mean by rights. That much of the legal academy, especially the left legal academy, but also conservative legal academy, is called into question the value of rights as a legal construction over the last 40 or 50 years. Claims of liberal inclusion and equality are often said to just sustain and reinforce existing hierarchies, that rights are not really a very valuable tool for challenging capitalist hierarchies, imperialism, racism, heteronormativity, and the like. We partly agree with that, but we're mixed about that position because one can certainly point to lots of struggles around liberal rights that have made a difference for advancing inclusion and equality, although in a very mixed kind of way. But for us, liberal equality and racist inequality are not the only options. We identify a third tradition, one exemplified by the history of Filipino and other racialized labor activists. We call this rights radicalism. Rights radicalism is defined by, on one hand, invoking liberal rights in the service of movements to try and transform society in a more egalitarian, inclusionary, and democratic way, and sometimes actually reconstructing traditional liberal rights with different meanings, to reconstruct them with further reach and with different content. And that's one of the things, that's what Patricia Williams called the alchemy of rights, which is reconstructing rights and rendering equality out of substantive social justice and meaningful substantive equality from pure abstract formal procedural equality, which is the hallmark of liberal legality. And that's one of the things that the cannery workers were trying to do in the most recent period in Wards Cove, which is to reconstruct anti-discrimination law, and specifically the disparate impact standard, to reach further, to go deeper, and to be a more transformative force. Okay, I'm gonna stop there. George, do you wanna say a few things?
So thanks, Michael. I just want to say a couple things. I won't dispute your account of my role other than just to say you're very gracious in that. I just want to emphasize something you said at the beginning, was just in add a little bit to it, just how moved we both are by the participation in this event today. And I think it's emblematic of something, at least for me, that was so valuable in working on this book. My prior books had been further back in history when I never did interviews before this book, and it was incredible that the people who were part of this story, some of whom are on the panel tonight, others who are in the audience, who talked to us and shared this story with us as two outsiders and trusted us with it, and how moved we were all the way through just by the brilliance and the courage and the tenacity of the activists that we study. So having Cindy and Terri and Nemesio here on this panel really means a lot to both of us, and also just people in the audience. I'm a little nervous about it to hear what people have to say about the finished product, but that I think was to me, in the sort of heart of working on the book, was just being trusted with the story. And it's a fascinating story and an inspiring story, I think, for current and future generations of young activists to know what the people that we studied were capable of doing and were able to do. So I'm eager to hear what others on the panel have to say in reaction to the book tonight.
Thanks, George. That's kind of what I was going to say next. So I appreciate you saying that. I mean, one of the reasons why this book, almost 25 years from the moment when it was first conceived and research began, was part of just being daunted by the scale of the project, but also the fact that we were, elite white professors, writing about movements of people who've been subject to historical, racial, and class domination, subjugation. And how do we deal with that? How do we negotiate that? How do we try and tell a story that makes sense from our academic perspective, but doesn't do too much injustice or harm to the actual lived lives of the people we're writing about? And I can only agree with George that so many people have been very helpful and cooperative and supportive, which matters a lot, because we were always questioning whether we were really going to do this in a decent kind of constructive way. Yeah. So we really do appreciate it. So that brings me to, it's my job next to introduce the panelists who are going to talk about the book or talk about the story. We're going to begin with an academic commentator, and that's Megan Ming Francis. Megan is an associate professor of political science and adjunct professor of law, societies, and justice at the University of Washington. She is a greatly admired and much cherished colleague. She specializes in research and teaching on race, law, and American political development. She's the author of the award-winning book, Civil Rights in the Making of the Modern American State. Her most recent book projects address the criminal punishment system in the post-Civil War South and the complicated relationship of philanthropy to egalitarian social movements. Look forward to what you have to say, Professor Francis.
Great, thank you. Thank you so much. It's a pleasure to be here. I want to thank everyone for virtually joining us on this evening, or perhaps this morning, as Michael said, and just want to express my deep gratitude to Michael and George for writing such an incredible book, and then as well as to the Bridges Center for hosting this incredible event today on this snowy day in Seattle. All right, so I was just kind of taking in the description of the book from Michael and George, and they have covered a little bit that I wanted to. And so I think what I'm going to do is to speak a bit about what I found helpful and why I think this book is so important. And hopefully this entire panel, and maybe something that I will say, will convince you to go out and go and get this book, because it's truly fantastic, and I plan on teaching it. So I'm always, in terms of kind of my positionality as a scholar, in terms of what I'm interested in and the stories that I find fascinating, is that I often say that I'm interested in stories that we think we know well, but told in different ways. And the story about Filipino labor activists is such a story. And it's a story about also kind of where we are in terms of this year in 2021. It's a story also about who this country is, about who this country has been, and who this country can be. The best part, I think, of this book, despite its kind of searing and incredible arguments, is the ambitiousness of this book. The historical narrative covers the entire 20th century, when so much was seemingly up for grabs and not that much was certain. I think many scholars, especially in kind of my field, where political science, shy away from these types of great projects because they can become so unwieldy. I myself, as somebody who also does a little bit of interviews, but a lot of archival research, I get overwhelmed with these kind of long decades periods, but McCann and Lovell have leaned in. And what you get is something that is so rich. Michael spoke, of course, in his comments about kind of this much bigger temporal landscape that they cover. And I don't think that they would have, or you get this type of kind of really interesting story, rich story, unless you're able actually to cover that long period of time. This also kind of also touches on, I was really interested, I've been having conversations with both George and Michael about this book for a number of years now. And I think initially, I haven't said this to them, initially I was curious, I was like, how are you guys going to cover all of this history in one book? and make it make sense. Because I know that both of you guys are theoretical. And so how is that also going to tie into the history? And I just want to just appreciate the structure of the book. For those who have not yet had the opportunity to read it, the introduction is an incredibly thoughtful theory chapter where they lay out the stakes of the book. And then the bulk of the book is really the narrative story. So if you're like, you know what, I'm not that interested in the theory, which you should be, but you are really interested in this story, this history, then that is where kind of the bulk of the book is. And then the ending chapter coming back and bringing it all together and telling you why this is important and what we can take away from it. I just thought in terms of, we work with graduate students, and this is just, I think, an excellent model for how to combine interview data with a deep archival analysis and theory, and to make it all make sense. And I was just struck by the kind of the research design of this. I also found it really interesting in terms of from a methodological standpoint as well. I'm somebody who's often always interested in how qualitative researchers, the methods that they use and how they tell their story. Michael spoke in his introduction and spoke about how this in some ways was an example of legal storytelling, but I also really want to underscore that, and especially in the vein, in the tradition of critical race theory. I definitely think that this book is very much in that tradition. And I think that in so many ways also in understanding the work of both Michael and George, Michael in particular, the rights at work in George, this is not civil rights, focusing on telling a story about large institutions and structures from the perspective of people on the ground is something that I've always loved. And it's something that I have learned from both of them as scholars. And that has informed the way that I do my own work. And I think that just kind of as a note, a lot of the scholarship that comes out in the legal academy and so much of the work that comes out in American politics and in public law in the subfield in terms of political science often focuses on these big structures and institutions and political elites. And what they do here is something that I think is really great by telling a story about structures and institutions through actually people, organizers and activists on the ground. And in so many ways, they kind of spoke about or they wrote about in the book about how this in some ways is a kind of a history of recovery, but I also think that it's a type of reparative history as well as writing back into a story that has already been written, the voices of people that have not been in that story. And so I think that's really important. The fundamental question that is still in the background that I'm going to continue to hold with me, even after this book, are what are the prospects for continued and future legal contestation from below amid the tentacles of the racial capitalist state? What are the limitations to liberal principles of equal rights? Where they end in the conclusion of the book is, right, on one hand, Michael spoke about this in his comments, that law is violent in the service of racial and capitalist domination oftentimes. And this is a quote from the end, law still provides one of the most important institutionalized sites and discursive resources for subaltern group resistance to and contestation over hegemonic policies, practices, and relationships in both state and society. And the reason why I'm highlighting this is because I also feel like for those scholars out there that oftentimes there seems to be kind of an inability to hold the tension. And I really want to appreciate the ability to hold the contradictory power between enforcement and contestation. And I think that's really useful. There seems, especially right now, it feels like in some left circles, like in terms of let's throw rights out, perhaps human rights discourse, perhaps rights discourse is not useful. And I think I don't think you're necessarily, it seems, on either side, but it seems that you are thinking through that in a really thoughtful way. In terms of the contributions to scholarship that this book helps shed lights on, I mean, in terms of obviously a lot of important areas, but for me, there was three big contributions that stuck out to me. And I'm going to say them in the form of questions, which is one, what is the role of the law in mediating power relationships? And there's, I think, a lot of ways to think about this. One, in the area of rights discourse. One, I loved this idea in terms of legal orders, different from sometimes we talk, especially in political science, about the role of racial orders. And I think that this idea about legal orders is so important and useful, and we need to talk about that much more. Two, how is the racial capitalist state operating and intersecting with legal institutions? And I think a tremendous contribution of this work is to think about and to theorize and to articulate the role of racial capitalism in the law and through legal institutions. And also, as connected to that, also the role of the law and how it's violence and how violence is structuring and working through the racial capitalist state. And then three, I spent a long time, and this is in part because of where my research is, thinking about racialized labor struggles and people of color social movements. And I really see this as a tremendous contribution to the research on race and social movements. And kind of in the background for me, and obviously through conversations that I've had with both authors here, I've been thinking a lot about how should we understand the story of Filipino labor activists, and where does that fit, and how does that intersect at different points with the long Black freedom movement, in terms of the activities, the strategies that the kind of different set of activists and organizers are thinking about and trying out. And then finally here, just kind of a long thought here. Well, a question and then a thought. I mean, in terms of, I guess I'm curious, and this is me getting ahead of the audience queue here. But I guess I was hoping that both authors could say a little bit more about, in part because I want to hear them, about what do you want the readers to take away in terms of the academics and the larger public. I think, Michael, you gestured to that in terms of, like, we can talk about Trump. I don't think we need to talk fully about Trump, but especially coming out of a contentious election and the January 6th insurrection moment here, and what needs to happen to move forward. I do think that there is a lot in this book that, like, you guys could point us to. Finally, I think McCann and Lovell's book breaks new ground. I have no doubt about that in legal mobilization, and speaks to new frontiers in the study of social movements, race and politics, and racial capitalism. In conclusion, I'm excited about this project, in part because of my work on social movement activism, Black politics, and my sometimes uneasy relationship with legal scholarship. The real struggles, as well as the unrealized visions of radical activists, provide us with an alternative epistemology for understanding structural injustice, as well as for imagining how to resist. I believe that by studying not only the critiques offered by radical social movements, but also their visions for transformative change, the edges of legal scholarship can be expanded. A deeper set of critiques and a longer set of histories of colonialism, of settler colonialism, the Atlantic slave trade, and mass incarceration centered, and a bolder project of transformation forwarded. Union by Law, I think, is part of this. The conclusions drawn from within these pages should, I think, push legal scholars toward a broader frame for understanding how law, the market, and the state co-produce intersectional structural inequality, and how people on the margins have organized to fight back within law and especially outside. And then finally, I promise this time, I think one of the things, especially because I read an earlier version of this in 2000, I think 18, was it that long ago, or 2019? And so reading this now after everything that has happened over this past year has been so enriching for me, because it has helped me imagine new possibilities, and especially coming out of a spring and summer of racial justice, and kind of the call to imagine new forms of being, new forms of organizing, and like thinking about how to make the impossible possible. I believe Union by Law is definitely helping me do that, and I think can help others do that as well. So just thank you so much. I really appreciate this book.
Wow, thanks, Megan. Means a lot, because we think very highly of you as a scholar. We know that you've been there all along with this project. Okay, I think what we'll do is, since each of the panels will probably have questions, we'll just hold off and maybe address some of those questions when everybody is done, if that's okay. Okay, so our next panelist is Cindy Domingo, second generation Filipino American, daughter of a cannery worker father. She was an activist for many social justice causes ever since leaving college, University of Washington. She was a leader of the KDP, or the Union of Democratic Filipinos, and a leading force in the Committee for Justice for Domingo and Viernes, following the murders of Sonia Domingo and Jean Viernes. She has served since 1994 as the Chief of Staff for King County Government. She's an amazing, abundantly generous person who greatly helped with the book throughout its development and also in generating publicity for this book launch. And we are greatly thankful for everything you've done, Cindy. Look forward to we haven't heard your reaction to the book.
Thank you, Michael, and thank you for Andrew, especially for organizing this event, and everyone here tonight. I've looked at the list, and it's so wonderful to see so many people that I know that feel it was important to set aside the time to come to this book launch. You know, tonight when I look at the list, it's like a family gathering that has come together for the purposes of telling a family story that spans generations, that spans history, a story that few know, a story that has been told often in pieces, but never in its entirety as it is told in this book, Union by Law. I want very much to thank George Lovell and especially Michael for telling our story so that our story, as told in the book, can take its place in American history and Philippine history. You know, I first met Michael around 1996, 1998. I didn't realize it was 25 years that has taken this book. And it's interesting that another book about the Union of Democratic Filipinos, the KDP, that Michael and George write about in the book, also wrote a book that took over 20 years, A Time to Rise, the collected memoirs of the Union of Democratic Filipinos. And we know that both our books took a very long time to write, but it is well worth the wait. In 1998, Michael attended the 25th anniversary of the founding of the KDP in Oakland. And that's when our long relationship with the members of the KDP and members of the organization LELO, A Legacy of Equality, Leadership, and Organizing, both organizations and members who helped make the history that Michael and George have written about. The KDP opened their gathering in 1998 to Michael, and he was really the only person outside of KDP members that was allowed to attend the non-public parts of the KDP reunion. And it was at this KDP gathering we introduced Michael, and that we entrusted Michael with our KDP history, our LELO history, and the history that's in this book. And as Michael said, you know, they had their apprehensions and we had our apprehensions of turning our history over to two white male academics, but we had the instinct that our story could be told by them. And with this book, we know that our initial and continued trust in him and George was well placed as they have produced a book that we can all be proud of. You know, I also want to thank Michael and George for dedicating this book to the legacy of Sonia Domingo and Jean Viernes. And the dedication says, dedicated to Sonia and Jean, whose struggles for social justice have so inspired us and many others. This year on June 1st will be the 40th year of the assassinations that took Sonia and Jean from us. And as someone who has spent the majority of my life's work ensuring that Sonia and Jean's legacy is firmly implanted in history, it gave me great pride to see that dedication. Because unfortunately, the contributions of Filipino Americans and the struggle against colonialism and imperialism by the Philippine movement remains largely unknown to people. And that's why this book is so important. Even though Filipinos have been a part of American history since the turn of the 20th century, even in our own community, much less in the wider American communities, our history is unknown, and especially our contributions as workers, our contributions to the struggle for human and civil rights. Recently, I reread a poem by Carlos Bulosan. Carlos Bulosan is probably the most well-known Filipino American writer who wrote the book America's in the Heart, in which every Asian American studies course and every Filipino American course must read. And he wrote a poem called I Want the Wide American Earth. And I read it because as I'm part of a committee that is creating a 4-panel mural to be painted by muralist Eliseo Art Silva. And this mural to be finished in June will be part of the Filipino Community Village in Seattle. So I raised this poem and the content of this poem because it's Bulosan's poem, which will be the title of our mural, reflects our aspirations to be accepted as part of America, that we, and actually all workers, have faced racism, violence, and exploitation. But we have also contributed, in spite of those, the barriers that we have faced, we have all contributed to the making of the United States and deserve to be part of the wide American earth in all its beauty and acceptance. In writing Union by Law, Michael has made a contribution to helping us fulfill our dreams, to be part of that wide American earth, to be part of what Bulosan writes about in that poem. And by telling our history, by telling about our struggles and contributions for the struggle of human rights, Michael has made that great contribution to ensuring that our history is told. I also want to say, you know, I really enjoyed the method that Michael and George talked about in terms of doing this book by using the voices of the workers that made this history in Lilo and in the KDP. It's always been so important to me that our voices are reflected in anyone that's writing our history. And so I want to say, as I read parts of this book, I was particularly touched that Michael gave tribute, especially to the brilliance of our comrade Terri Scott, co-founder of Lilo and the United Construction Workers Association. They give tribute to Terri for what Michael calls, and other scholars call, legal mobilization. Terri would never call it that, but that is what the scholars call it. Terri always liked to describe himself as an ordinary worker. But what we who worked with Terri all knew, and I'm sure those that have interviewed him and met him, was that he was actually a working class genius, skilled in every way in waging class struggle. I used to spend 1 hour a day talking to Terri, and to this day, he inspires me to go on with read form Lilo as a law office and hiring lawyers that would take direction from the workers. So in this chapter 4, Lilo, ACWA, Alaska Canning Workers, and the politics of civil rights mobilization. The opening of that chapter has a quote from Terri, quote, "We had figured out some sophisticated approaches of dealing with the law, so we could not just demonstrate, but we would also file lawsuits and make up causes of action and whatever. That's what our and say, can we file a lawsuit on the basis of this? And he'd make up some cause of action and we would file it. And pretty soon we're sitting up in the courthouse like we had some legitimate claim to be there. It was really creative and effective. The second quote is from Michael Simmons, in which he's describing Tyree. Tyree Scott would say, poor people should be able to treat their lawyers like rich people treat their lawyers. They tell them what to do. All these movement lawyers always try to tell the poor folks what to do. What may be the best legal strategy may not be the best movement strategy. And if you're trying to build a movement, you say, fuck the law, we're trying to build something here. And we did not defer to lawyers at all, at any time. That is the genesis of LELO. And the last quote was Michael Fox, one of our key lawyers at LELO. This was not radical. It was just democratic politics. So you can see Tyree's thinking and his brilliance in terms of developing the strategy around LELO and how we would use legal cases to wage class struggle. Michael also gives tribute to my brother Nemesio, who will speak after me, who oftentimes doesn't get the credit for his brilliance also, because he's low-key, soft-spoken, but all the more, just like Tyree, understood class struggle and figured key in the strategy of legal mobilization in all its facets. Nemesio has presented extensively on the reconstruction of civil rights in this country, and his perspective is best represented by this quote that's in chapter 6, in a chapter about Wards Cove versus Atonio. So Nemesio said in 2003, we think that if civil rights were based on human rights construct, it would be stronger and would be less prone to the kind of deconstruction that has happened in this country. It would change the economic foundations of this country. Every human being deserves adequate housing, adequate medical care, adequate education, and jobs that talk about the entire human being rather than a legal system that folks work in. Lastly, Michael is very correct when he described us, that at the center of our work was an anti-racist, anti-capitalist, and anti-imperialist vision and ideology. And that remains true to this day for people that are working in LELO, as well as people who were in the KDP who continue to do work around the Philippines. Union by law comes at a very important juncture in our country. Yesterday, as I watched the impeachment hearings on the insurrection of the Capitol in Washington, D.C., I couldn't help but think that we have been the ones fighting to create and save the real democracy in the United States. And we have done it in the streets, in our homes, in our schools, in the courts, all the way to the Supreme Court and in Congress. We are the ones that have given true meaning to the word democracy and brought life to it through our life's work. And that was the brilliance of our movement and continues today. And Michael captures that in his book. We never narrowed our strategy to only marching in the streets. We took our struggle to the courts to test the limits of the law, to test the limits of Congress. We organized ourselves into organizations that are very much alive today. And then oftentimes we went back to the streets. We had a vision and we used every strategy to get us as close to that vision as we could get. And as we proceeded, we exposed how capitalism and its institutions are all about power and are always about standing in the way of workers' power. You know, I want to close with my favorite quote, and as it's Black History Month, I think that it's very appropriate. It is a quote that I think about all the time, and one that I found after we won the landmark judgment in the civil suit around Salmi and Jean's assassination against Ferdinand and Milda Marcos. And it summed up how I felt after 8 years of struggle, and actually how I feel today about every struggle that I enter into. And the quote is from Frederick Douglass: "In the struggle for justice, the only reward is the opportunity to be in the struggle. You can't expect that you're going to have it tomorrow. You just have to keep working on it." We never won the Wards Cove case, but through that work and through this book, many had the opportunity to be involved in that struggle. And through this book, many more will have the opportunity to learn about the role that Filipinos played. They'll learn about the multiracial nature of our struggle, of how African Americans, white women, Filipinos, Asian Americans, Native Alaskans, Latinos, all came together, and how they struggled through all of those institutions and won rights and lost. And we will continue to look at this book, to learn from it, and it will help us as we continue to play roles in the struggle for civil and human rights. So thank you. So with that, I'd like to turn it over to my brother Nemesio.
Okay, thank you very much, Cindy. That was very moving, actually. Thanks. Next, we have Cindy's brother, Nemesio Domingo Jr. He's the eldest of Domingo's siblings. He started his activism as a University of Washington student and cannery worker. Together with his brother Silmi, he formed the Alaska Cannery Workers Association, ACWA. He was a lead plaintiff in a successful class action lawsuit against New England Fish Company. And Cindy alluded to, he's sort of the legal, probably along with Terri, the real brilliant legal strategist in this group of activists, at least as far as I can tell. He later served as co-chair for the steering committee for the Committee for Justice for Domingo and Viernes. His efforts remain focused on the work of the ACWA and LILO. I should say also something for people who don't know, you hear this term LILO. LILO actually has gone through a change. Originally, it was the Northwest Labor and Employment Law Office, and then eventually it was changed to the Legacy of Equality, Leadership, and Organizing. But nevertheless, it's mostly the same people, and the mission to some degree has remained consistent. And Nemesio, to this day, he's still the chair of LILO's board. Nemesio, I look forward to what you have to say.
Actually, emeritus.
Oh, emeritus, okay. I'm just about emeritus too, so.
Well, thank you for the invite, and thank you, Michael and George, for a really wonderful book. I received Union by Law 3 weeks ago and started reading 2 weeks ago. Although the book for me is very dense reading, it did lay out a really compelling structure to understand the Filipino labor struggle in the United States. It kind of reminded me of a book that I read in when I was undergraduate at the University of Washington in the late 60s. It was called The Structure of Scientific Revolution by Thomas Kuhn. So your book gave really a good framework to understand the history and the struggle of Filipinos. I appreciate the details of the book because context is important to understand the sweeping arc of any human struggle. I'm just hoping, though, that you'll have a senior citizen edition with larger print. It's easier to read the book by the bedside. I did want to talk to you about 3 things I found interesting in the book. And that was how we got to this idea of looking at civil rights in this country as a process of construction, deconstruction, reconstruction, and that this is a cycle that goes on because of how our political system is set up. Secondly, I wanted to talk a little bit about how we eventually reframe our work in terms of civil rights as needing to be reframed in the idea of human rights. You made reference in the book about how our earlier forefathers in the union labor had come to that conclusion. And much of that was based on ideology that they had organized around. We kind of stumbled on this idea of human rights. And then thirdly, if I've got enough time, I want to talk about your concept of racial innocence, because it answered a lot of questions about how it is that people think that if you lose a lawsuit, then you're the loser. And if you are white and you win one of these kinds of cases, that you cannot possibly be discriminatory. And that folks find a way to rationalize what they've done using that concept of racial innocence, which comes out of some legal battle. So, so I want to put in to give you some context on these three things I'm talking about. The context of the cases is that we actually envisioned one case that would take the entire industry into one case. And that was a model that we patterned after United Construction Workers case. If they took the construction industry as a whole in King County, was able to get a ruling that affected the entire industry. In our case, what happened was the case was broken up essentially into three cases. Domingo versus New England Fish Company, Cervantes versus Nemesio Domingo, and then the notorious Atonio versus Wards Cove. So things started in 1973 after the 72 season. In your book, you describe how because of the work of Salome and Michael Wu, they came together at the end of that season and organized under the McCann and Workers Association. And in 74, we started in earnest with the cases. But it took 10 years to win the first two cases. In 1984, the Ninth Circuit Court of Appeals finally sealed our victory in Domingo versus Nemesio, and gave us everything that we had sued for, with the exception of segregated housing. The following year, in 1985, Judge Barbara Rothstein of the local circuit court here overruled a magistrate's ruling against us in the and based on the New England case, essentially gave us a verdict that was identical and in some ways even more generous than the Nemesio case. So here we were 10 years out, and Tony Wards was not even essentially on the horizon. And Terri Mast became concerned about what the impact of this case lagging behind would be. And so in 1988, he asked me to prepare a presentation on what might be the legal focus of LILO as it relates to Wards Cove. Because in the meantime, over those 10 years plus, we were alarmed at how the courts were getting more conservative, particularly because Ronald Reagan was able to appoint the various justices in the system. And so we were re-examining what our focus should be. One thing that really did impact our re-examining as well was this obscure rule in the Ninth Circuit called Rule 23B. And 23B was supposed to be a rule that disallowed attorneys from talking to potential class members. And we as an organization of workers thought that was not right, and so we continued organizing and talking to workers, making public appearances. And this was critical because this was a hammer being used over our attorneys. This became really contentious between us and our attorneys. It got to the point where every time I made a presentation, I would introduce in the crowd the attorneys for Wards Cove and the canning industry as a matter of, I guess, courtesy to say, well, in the audience are also these attorneys, and this is what those attorneys are looking for in my presentation. Well, in our re-examination, Gary Owens, a LILO member and founding member of the Seattle chapter of the Black Panther Party, and also Cindy's husband, noted how the courts in our history have swung widely between progressive and reactionary rulings on civil rights. So we began to view civil rights in a pattern of construction, deconstruction, reconstruction. We saw the first construction with the passage of the 13th Amendment, which abolished slavery in 1865. That was before the Civil War ended. And the 14th Amendment, which essentially was a federal enforcement of civil rights laws in 1868. Now, no sooner had those civil rights laws were in place, and there was reaction among the during the period of Reconstruction period in 1866 and 1877. And one of the crowning legal landmarks is collectively, there are 5 cases, and they're referred to as the civil rights cases of 1883. And the purpose that the Supreme Court brought these 5 cases and issued one ruling was that they were going about to neuter the Civil Rights Act of 1875. So we see this deconstruction an important milestone, I think. It was 1896 Beasley versus Ferguson, which was a ruling that said that separate but equal is constitutional. Now, in 1954, I think we see a reconstruction of civil rights with 1954 with Brown versus the Board of Education. And we see this Reconstruction happening. And the milestone of this Reconstruction is the 64 Civil Rights Act. However, what we see is even after the 64 Civil Rights Act, we see this gradual shift again of conservative attempts to rein in the 64 Civil Rights Act. And this is where Wards Cove plays a very important part, and why we were most concerned of it lagging behind the other two cases. Because what we were aware of was that one of the most important elements of civil rights was the concept of disparate treatment, meaning that if you had some kind of requirement that impacted a group of people, and even though you may not on the surface intend it to be discriminatory, but in fact it was discriminatory, then it was protected under the 64 Civil Rights Act. That case was established for the Duke Power Company, in which the requirements and testing of Black candidates essentially nullified people's ability to be hired. So we were aware that this was a major target of legal, conservative legal people, and that we were really apprehensive when the case was referred to the Supreme Court. And sure enough, that's exactly what happened, is that they used that case to dismantle civil rights, at least that part of the Civil Rights Act. My 10 minutes is almost up, but I just want to talk about how we came about to view the issue of civil rights as human rights. Part of our review of what we would do legally as a legal focus is just recognizing that legal rights were so fragile. You can see that what has happened, with the impeachment thing, is just how fragile some of our rights are. And so we came across, more by accident, the United Nations statement on Declaration of Human Rights. And we thought that this was really something that other nations had already looked at, and that a lot of the constitutions in Europe were actually based on that statement. Ironically, two nations did not ratify the Declaration of Human Rights. One was the United States, and the other one was the Soviet Union. But nevertheless, we thought that we needed to reframe our issues within that cloak of human rights. And then lastly, just really quickly about this racial innocence. 2 years ago, Cindy somehow convinced me to go down to Berkeley to talk about Wards Cove. And in the audience, it was a large audience, but there was only one white person there. And it turned out to be one of the attorneys for speed attorney school, Wards Cove. And he had heard that I was going to come down to the speed. And he now lives in the Midwest. So he traveled all that way. And he was actually, I didn't notice at the time, he was trying to get the organizers to let him speak. And the organizers refused to, although I did acknowledge, not knowing he was the attorney at the time, allow him to ask questions. But he then, at the end of the meeting, I went over and talked to him, and he had this list of questions that you wanted to ask. And I think he might have talked to the two of you folks in the past. I know he had talked to Michael Fox, he had talked to Rami Arditi. And there's no doubt in my mind this guy is a very honest and decent person. But somehow he thought that because they won in court and that, he could show the technical things about what they did right. And again, I thought that this was something you want to teach in a law class on procedures. But because you win, it doesn't make you less liable to be to have been part of a discriminatory system. So winning legally does not give you the hope of being now somehow negating the people's struggle. So I'll just end there.
Thank you, Nemesio. So I wish I would have had some of those quotes actually that could have put in the book. Maybe if there's a second volume, we'll add some of what you just said. And then finally, but certainly not least, is Terri Mast. Terri Mast was born and raised in Seattle. She was a former cannery worker, an anti-war and feminist activist, a member of the KDP, the Union of Democratic Filipinos. She was partner to Cindy Domingo. She played leadership roles in the Rank and File Committee for Union Reform and served as president of the ILWU 37 after the murders of Selmy and Jean. She is currently the Secretary Treasurer of the Inland Boatmen's Union, which is the largest union that the cannery workers emerged with some years ago. Terri?
Thank you. And thank you everyone for joining us tonight. I must say, when I first received the book, it was a little intimidating at the volume and how much is actually in it. But I do want to thank both Michael and George for taking your time to write that wonderful book. Its rich history of the Filipino migration and the early immigrants' American experience and their contributions to the US society, and how you draw out the many hardships that they faced. It's not often and not enough that worker struggles and worker stories are told. So I certainly appreciate everything that you put in the book. And I just wanted to reflect tonight a little bit about what it sparked in me in terms of our union experience and seeing how much you were able to put in that book. It's a lot of history. I too wondered how it was possible that you could put everything in one place. And I certainly appreciate that you did that because it is such a rich history. One of the things I wanted to talk about is just to reflect on my own experience and what you were able to cover in the book. I worked in the industry in 1978 and 1979, and even at that time, there still was segregation. There still was Filipino mess hall, Filipino bunkhouse, etc. I was part of the rank and file committee that was built out of the 1970s. It was a continuation of the movement that Nemesio Domingo Jr., who just spoke, was a part of, as well as Selmy, and all the other workers that were involved in those class action suits that Nemesio just talked about. Many of them were blacklisted from the working in the industry after they filed those suits. We were certainly dealt a heavy lift, not only in dealing with the hostile industry, but the corruption within our union, some of that led to the filing of those lawsuits, because the union actually didn't take up those issues of discrimination in the industry within the union, but in fact, they benefited from it. And although the lawsuits, as Nemesio mentioned, they were against the industry, where some of the lawsuits that Tyree Scott and the trades had filed were also against the unions. And in this case, it was not against the union, it was against the companies. But through the process of the discovery in those lawsuits, even though we suspected it, it was confirmed in the discovery of those lawsuits that in fact the union leadership was complicit and that they were taking financial kickbacks and other gains from the employers. We understood that we weren't going to win everything through those lawsuits, and as Nemesio said, they took such a long time that we weren't going to make change in a very quick time. So we understood that then we needed to get back into the union and implement the reforms from within. And I appreciate in the book that Michael and George, that you do cover a lot of the history about the movement that came before us. And we were fortunate that many of the monongs or the elders that came before us were still around in the union, and that some of them still working in the industry up into their 70s and 80s, or they were around in the community. And we were able to draw from their experiences. They too were excited and energized by the emergence of new activism and willing to work with us on the reform movement. We relied on their militant traditions from the past. They too had a rank and file committee and their experiences, and implemented some of the same tactics that they had used in terms of building our movement. Knowing that we had to understand the past to make the connection and the corrections in the future. Like them, we wanted to build a democratic union that would speak for the workers and that would fight for equal rights and anti-discrimination on the job. Like them, we too had a broader vision, a broader political vision of international perspective of workers' rights. We were building relations with the workers in the Philippines and building connections with the labor movement there, so supporting the trade union rights under the repression of the Marcos dictatorship. We shared other similarities with their visions, their political visions. During their time, many of them were brought up under anti-American activities during the McCarthy era. And we too were red baited. And all of that was only used as a way to try to weaken our movement and the leadership in the union. After the murders of Jean and Selmy, it was those same old timers, monongs that we call them, that understood how important the work we were doing was and how dear this loss was. And it was them who was there every day to protect us, as well as the other left in the ILWU. Longshore locals also came to our side. Cindy talked about Carlos Belosan, and I didn't know Carlos, but in a lot of ways I felt like I did know him, because I was fortunate to know his close friends, Chris Monsalvis, past president of the ILWU Local 37, Barry Hatton, Josephine Patrick. These were the folks who we relied on and who helped us to build our movement. I wanted to share this little story. Recently, we found this book in the Union, and it was a book of poems of Carlos's. And they had used it was a book full of poems, and they had used it as a campaign when they were fundraising for the trials that the officers were undergoing during that period of un-American activities. And everyone who made a donation to the trial for the lawyers got one of Carlos's poems. And I just want to say that if you haven't read America's in the Heart, as Cindy said, please do. It is certainly a treasure, and Carlos was a treasure to our union and to our nation. Our legacy to our pioneers in the union, we did a oral history project of them as well as a way to, keep their legacy alive and to document the wonderful work and their experience, their American experience. Over the last 30 years, we have witnessed many changes in the salmon industry. Many of the companies have sold and the market has changed. It has moved away from predominantly canning to fresh frozen and fresh products of filleted and whole fish. And the fishing in Alaska has been depleted by the fish being taken on the high seas and by trawlers taking large portions before escapement. We witnessed the traditional land-based plants. Most of them are now closed and have moved offshore and to floating processors that are mainly non-union. What hasn't changed in the industry is the continuation of the exploitation of immigrant workforce, and more recently, the over-reliance of H-2B workers. The company is always looking for higher profits. In fact, one of the companies that was not part of the lawsuits, which was Peter Pan Seafoods, was one of our longest employers. And recently, they've operated 4 plants in Alaska. And recently, they have been bought out by an investment firm and a tycoon in the Alaska salmon industry. At this point in time, I just want to mention it because it's kind of a continuation that this company has been sold and they are not recognizing the union or any of the unions that were there in the plant. They've hired some of our former members and hundreds of H-2B workers from Eastern Europe. Again, exploiting workers who have limited rights here while working and are constantly under the threat of being sent home if for any reason. Many of them did. In fact, we are mounting an organizing campaign and many of them did sign union cards, but as soon as the agency that brought them here found out, they have rescinded those cards. Our union was built on struggle and will continue to fight for racial and economic justice for workers. This may be another chapter in the book, Mike and George, where this could be the end of Local 37 or Region 37, because if we are not successful, we will no longer represent anyone in the Alaska salmon industry. I just wanted to, close by saying, what I've learned and what your book talks about is how the law is used. And, we know that it's not always for workers, it's not always in our interest. The law doesn't always protect us. In fact, it's made very difficult for labor in terms of organizing. The laws are very difficult. But what I've learned is that in the midst of class struggle, that we have to use all our tools, and be that the legal system, governmental agencies, or whatever is in front of us. But most importantly, it's about building broad coalition, community affiliations, and building a workers' movement. I'm going to just stop there in the sake of time. So thank you.
Good evening, everyone. I'm Andrew Hedden. I'm the Associate Director of the Harry Bridges Center for Labor Studies, and I will be facilitating our question and answer this evening. In a moment, Michael and George are going to have a chance to respond to their panelists. And in the meantime, while they're responding, if you would like to submit any questions for the panelists or Michael and George, you're free to do that through the Zoom webinar interface. If you look at the bottom of your screen, you should see an option for Q&A, and you can submit a written question there. We'll also welcome spoken questions or spoken comments, but before we call on you for that, we'd like you to submit just a request to speak live in the question and answer box. That'll allow us just to identify you and be able to call on you. And I believe there is an option for me to turn on your audio so you can make a comment or question. And we will do that until the end of our event at 7 o'clock. But before we begin with questions, we'll give Michael and George a chance to respond to their panelists. So Michael and George.
Thanks, boy. There's so much to respond to. That was all just really great stuff. And I really appreciate the appreciation for what we've tried to do, whether we succeeded or not, but at least what we were trying to do. I think the panelists caught it. Just a couple of quick comments. One thing to begin with Megan's comments. In our preface, we address what we, and this was written 2 years ago, the implications of our book for understanding Trump. We say that we were surprised by the rise of Trump to some degree, and we shouldn't have been, because our book makes very clear that that's been a long part of an American history of white supremacy, xenophobia, anti-immigrant, on and on and on. I've written a lot recently about the dual legal orders, how we should look at Trump either as above the law and against rule of law, or just a different tradition of authoritarian law that goes deep into American history. He's just re-inhabiting and using again those traditions of racist law before World War II. Cindy was great, very inspiring in every way. I'm glad she brought up about Tyree, because we didn't have time to say anything about Tyree, I think, in the quick opening comments, but Tyree plays a very pivotal role in our book, because I think he played a very pivotal role in the history that we're telling. And I think calling him a working class genius is exactly right. I think each of you I would call a working class genius too, in different kinds of ways. But my first encounter with all this history was really through Tyree. I did a series of interviews with him and was working actually on some political stuff with him. And he said, "Oh, I've got all these records about, what we did." And I said, "Great." And we went out to his garage, and there were like 50 boxes. They were all mildewed and everything. That's one of the reasons it took 25 years to write the book, because I didn't know what to do with 25 boxes in a carport, because I'm not an archivist. Real quickly also, Nemesio, I really appreciate the relationship between civil rights and human rights, trying to expand the narrow liberal American tradition of civil rights through human rights. That's what we were trying to suggest, or not suggest, but argue that you and the whole movement was doing. And I think that's very important for all kinds of movements today. That's a big struggle. And I also like very much the argument that just because a lawyer might argue that that person or that party won in court doesn't mean they're right, and that should discourage people from struggling for justice. Finally, Terri said lots of great stuff. But I think one of the themes of the book and all the work that George and I do is that legal mobilization, litigating, claiming legal rights, fighting on legal terrain, whether it's courts or other terrain, is never a panacea. It's never going to be a quick way to win. In fact, winning in courts often doesn't get anything, but you have to use all the tools in the toolbox. That includes grassroots organizing, playing the media, legislation when necessary, electoral politics. It's just one of the tools, but you can't deny that it's a really important tool. So I really appreciate that. Also, the mention about Carlos Bulleson. One of the slightly intellectually risky things we did is trying to integrate a lot of Bulleson, especially into the discussion of the first generation, to make sense of the worker experiences, the literary voice for the workers' experience. I'm not sure that our social science kin will necessarily view that as appropriate, but we didn't really care. We thought that it added, and I hope that you found that it did too.
Yes.
Yeah. Okay. Enough. George, you want to say anything in response?
Just really quickly, thanking the panelists, but one thing that struck me was some of the language Cindy was using about how we were telling the story and this was the story. And I feel like when we were writing the book, that put a lot of pressure on us, thinking that we had that responsibility because we've been trusted. And one of the things that let me get past that, and I think helped us to finish the book, was that I don't think it is the version of the story. I think that there are multiple, and other people have told this parts of the story, and we learned a lot from them. And that includes the book that Cindy edited on the KDP, the book Ron Chu put together, Mike Withy's book that came out, I think, 1.5 years ago, and also work by Rick Baldos, and 2 really wonderful dissertations by Trevor Griffey and especially Ligaya Domingo stuff that we really learned a lot about. So I don't know that we own the story, but I'm really pleased that it resonated with the panelists, and parts of it seemed to capture a truth that had some meaning to them. So that really means a lot to me.
Yeah, I totally agree with that. Late in the first chapter, you can see where we talk about wrestling with our positionality as white elite university professors, and how dealing with the story and how are we going to tell their story, you know, but also tell our story and all that. But it's absolutely true that from the time when I first encountered this and began interviewing people, all these other books came out. You know, Lugai's dissertation and Ron Chu's book and Mike Withey's book and The Time to Rise by Cindy in the group. You know, but we just saw. I mean, that actually made us feel better because now our book would just be nested as another angle on all these things. It wouldn't stand out there. Nobody would be tempted to say this is the story. So that was actually kind of comforting or reassuring in a way. And also, I'll just reiterate, I think George said this earlier, just all the cooperation and encouragement and support from all of the activists, including especially those on the panel. It just meant a whole lot.
It may be the longest of the books and has the smallest print, but I don't know if it's the best.
I agree about the small print. Even, you know, I'm getting up there too, and it's challenging.
Great. Well, thanks, Michael and George. We've got some great questions coming in on the Q&A, and we have some people who've asked to speak. We're going to call on somebody now, Mike Withey, who is a attorney on the Cindy Domingo and Jean Vernet's case. We're going to call on you to make a comment.
Well, thank you very much. Can you all hear me?
Yes.
A great job on this book, both Michael and George. And I want to point out a really important aspect that you bring out, law as a contested terrain. It's on page 311. I really took this to heart. We learned 3 lessons, I think, from the great description you gave of the work of the Committee for Justice. When we formed that committee, we decided not to turn over to the Seattle Police Department or to the King County prosecutor the struggle for justice for our slain comrades. We formed the Committee for Justice independent of the state in order to bring that kind of pressure. And that was the visionary work that Terri and Cindy and others brought. And I think that's an important lesson. We don't want to turn over the struggle against white supremacy and domestic terrorism to the United States Senate. They ain't going to do it. We are. The second lesson, and thank you so much for bringing out the genius of Tyree Scott. Cindy, you're so right in how visionary Tyree was. And when we were representing the people arrested on the construction sites, and Tyree took the position, we don't recognize the legitimacy of these courts. We had a demonstration in the courtrooms, and we took the whole court system on, and we found ourselves in a jail cell with Tyree and Michael Wu and Todd Hawkins and myself. And I was going, well, I don't know if I even recognize the legitimacy of this jail cell. And Tyree told me, Mike, you got to learn one lesson. In the halls of justice, the only justice is in the halls. Don't turn over to the courts the struggle for justice. And that was a very important message. And the people in the African American community, the Filipino community in Seattle, the Native American community, El Centro de la Raza, no separate peace. That was our mantra. The third lesson I think we learned is that the political verdict precedes the legal verdict. Think about the importance of the fact that people of the Philippines overthrew Ferdinand Marcos. That set the stage for our victory in the courts against the regime, because and this is a beautiful part of your book, the essence of our struggle was international. And that's something that Terri and Cindy brought, the clearest kind of political leadership. This was an international struggle. And we had to root our struggle against, not only in the canneries, but also against the Marcos regime in international solidarity. So thank you so much for this book. It's just a tremendous contribution to the history of the struggle of Filipino Americans and all of us against injustice and oppressive hierarchies.
Thanks a lot, Mike. That matters a lot.
Thank you, Mike.
You bet, George.
Great. Well, we have a couple submitted questions that I'd like to pose to our authors now. The first is from Maricruz Castro, who writes, since you mentioned the Constitution during your speech, does your book also go into why the Philippine Constitution is a carbon copy of the US Constitution? It's a topic that they're asking, they say they'd always like to know more about. So there's the question about the Philippine legal system. And then another question, kind of also on the legal theme, comes from Jennifer Fredette, asking, I'm intrigued by this idea of the plural legal orders of the US. I've always thought of the liberal legal order as being premised on the existence of these different legal orders, for example, black codes, exclusionary laws, laws for the poor. What new things do you help us see when you break these legal orders apart and focus on there being separate orders? So there's two questions, one about the legal system in the Philippines and the Constitution, and the other about different legal orders.
Thanks for those questions. About the ways in which the Philippine Constitution was sort of mimicked on the U.S. Constitution, that we do have an early, subchapter about that, and clearly, I mean, when America imposed colonial rule, it's clear what they're trying to do, what our leaders were trying to do, I speak part of the white political establishment, which was to create a government that looked like sort of a liberal constitutional order, but in fact was quite different. The Philippine Constitution was quite different in that it invested overwhelming authority in the executive body and invested very little authority in the representative bodies in the legislature, especially the bodies that were representing the non-mestizo Philippine elite. And so it built into the Constitution a logic of racial separation and discrimination, even though it doesn't say that, but the structure of it is indirectly in the context very much that. And that's very important for 20th century Philippines, because there's a history of sort of strongmen executive leaders, and the Constitution to some degree has enabled that. And secondly, from the very beginning, the courts were not granted very many powers in much role, which meant that courts were never really much of a judicial check on strongmen executive leaders like Marcos. And that's especially true in the Marcos period, when the courts just sort of deferred, rolled over for Marcos. And all that goes back to the original constitutional structure. Now, neither of us are experts in that, but we did a lot of study of that because as part of our story, that's the moment when the US really directly engages with the Philippines, and the first moment when kind of racial hierarchy is imposed through law. And then a whole lot else, a whole lot of statutes that are passed and so forth. But the constitutional structure reinscribes both class and race hierarchy into and the primacy of executive power over representation, especially representation for the working class and for the southern Philippines and the Muslim populations and all those kinds of things. So we deal with that, and we base that on lots of secondary literature by people who know more about it than we do, but we do address that. On Jennifer Fredette's question, thanks. That's our question. What does the separate legal orders really help us understand that we didn't already know? I think that, it's not very surprising when we lay out that there were these separate legal orders. There were different bodies of law for differently situated people. I think one of the things we try and underline is that this is, structured by racial capitalism. So racialization of either low-wage workers or people whose land was taken away from them, or people who were just disposable in a capitalist economy. And racialization was part of that. So that's not new in some ways, but we try and highlight that. I think that the contribution we make is saying this doesn't go away after World War II, despite the view that liberal constitutionalism prevailed, and now race neutrality and gender neutrality prevailed, and the remnants of white supremacy have been erased from American law. That is just inaccurate, we think. We think that what happened was that due process and constitutional proceduralism imparted a kind of mask that hid what's right there in plain sight for all of us to see, which is the way in which mass incarceration, immigration, law treatment of immigrants, the criminalization of poor people, and on and on and on, and that is still going on. And by tracing that historically and seeing how this sort of procedural mask or cloak that was imposed, can't deny that that is still going on. It's new in form, but it's similar functionally and to the targeted populations. And I think one of the contributions we try and make in the book is to include in that discussion of mass incarceration, immigration, and criminalization of the poor is also standard working conditions, labor law, and the prerogatives that law grants to employers to basically treat workers almost any way they want. There are very few legal rights protections, statutory protections for workers, especially for low-wage workers of color and women. And so we want to, put that into the mix, saying there's still a lot of these remnants of very traditional, what we would call repressive or illiberal, or one could call them authoritarian law in American history that are at work, but they look different because of the introduction and this sort of play acting of due process. I'm not sure, and that's one of the issues, whether that really works or not. We've heard lots of people say that that's actually a very powerful part of the book, but I've been trying to work on that since then. I think I can make a more compelling argument now than we did in the book, but we'll see. What do you think, George?
About whether you can make a more compelling argument?
Yeah, well, I'm sure I can make a more compelling argument, but it just in response to the question, either of those.
Yeah, no, I mean, I think that's fine. I think we can move on to the
Okay.
next one. That's good.
Okay.
Great, thank you. We now have another request to speak. Ted from Canada, I'm going to call on you here, and Ted, feel free to make your comment or question. Just waiting a second for Ted to unmute.
Yeah, I was just saying that I'm thankful that I was able to participate in this discussion through an invitation by a friend from the United States. But I have been in Canada for 50 years, and I followed the Cindy and Domingo case when it happened, and since then I have monitored the issue. I have read the book A Time to Rise and the lawyer's book on summary execution, and now I hope to have your book in my collection. I was part of the anti-Marcos struggle in Canada in the 80s after the Aquino assassination, but we don't have that kind of union alliances here. We are in new immigration. Filipinos have immigrated to Canada only about 50 years ago, unlike the Philippine American situation. So personally, I look at the example of our Filipino American compatriots who struggle for justice. So I'm very eager to read your book. And as I said, I want to add it to my collection of the history. And I was surprised that in your introduction that, I was invited to to participate. I did not know that the book was practically entirely the history of the Filipino struggle, the labor struggle. So as I said, it would be a model for us here in Canada to look at how we would build up our struggle. And I am thankful for the two of you to devote your time to such a very voluminous history, 500 pages or so. And it took 25 years. And I'm inspired by that because I'm also thinking of doing a book for the progressive movement in Canada, which I was involved, and almost discouraged that I could not maybe do it because I'm already 81 years old. But to know that it took you 25 years to finish this book is an inspiration. Thank you.
I should add that there's something quite inaccurate about the 25 years. I began the book 25 years ago, around 1996, 1997. That's when I first interviewed Terri and then Cindy and Terri and others, and was planning to write the book. And for a whole variety of reasons, just didn't think I was ready to do it. and was again sort of stumbling over this. Am I really the right person to write this? And a whole lot. And then in the meantime, I wrote 3 other books and other projects, and I was chair of political science department and started a law, society, and justice program, and only came back to it around 2010 or 2011. And when I did that, so it was only 10 years to write the book, I think. And that's when I asked George to join me, realizing it was a daunting project and that we had a lot of similar interests, and we thought similarly, and I thought the book would be better by adding him. So it wasn't 25 years to write it. It was 25 years from when I started it to when it was done, but it was really in about 10 years of writing the book, in which I also wrote several other books too. But yeah, somebody should do that in Canada. But it's interesting because when I started giving talks on the book a couple of years ago, lots of people have pointed me to literature about Filipino experiences, but the canneries in Canada, and to work on Canada as a settler colonial tradition, and all the parallels to the US, which are not surprising. I just didn't know much about that. So there is a lot of literature to build on already. But that would probably be, we'd love to see a parallel kind of project about the Canadian experience.
Thank you.
Great. Thank you, Ted, for that comment. We have a written question from Jolene Avila. Says, I don't have access to the book as I'm based in the Philippines, but I remember speaking with George and Michael about this project many years ago. I'm curious, how do you think the Wards Cove case changed the definition or understanding in the legal, academic arena and beyond of racism and racial discrimination in the United States?
I'll let you go on that one, George.
Well, I mean, I think it was one of a series of cases at that time when the Supreme Court really clamped down on what had been a promising area of anti-discrimination law that I think maybe nobody in more interesting ways than the Northwest Filipino activists, but there were other people who were trying to take advantage of the openings in law that were there. And it really was, in combination with other cases, the sort of end of that promise. So it's tragic, I think. And I think part of what's sad about it looking back is that the earlier possibilities got forgotten because of the killing off of the possibilities that happened in that case. It's like law gets written backwards, so that the way it comes out is sort of believed to be the way that it always was. And I think now people don't realize that there was that promise there that people really did fight for and struggle for before it got taken away by the Reagan appointees and the retrenchment on the court. So it's a significant case and a landmark, and it's also emblematic of a bigger trend that had happened that's quite tragic.
Yeah, I think that's absolutely right. I mean, I wouldn't say that Wards Cove caused anything per se. It was part of a larger set of changes. It was very symbolic, very emblematic. A number of people have written that it did, symbolically, it was very important. I had written a book earlier about women challenging wage equity through using a disparate impact test, the same, very similar argument to what the cannery workers were arguing, and with a lot of success in the 1970s and early 80s. And through that book, you could see the beginnings of the courts closing down on this expansive idea of disparate impact. And in some ways, it was easier to do for gender. I won't get into why disparate impact was easier to demonstrate in ways that courts accepted in gender cases. But nevertheless, that's when I first saw it. And what killed the movement for gender-based wage equity to a large extent was the Wards Cove case. It was a sort of final nail in a slowly closing coffin, or whatever image one wants to use, but symbolically, it was hugely impactful. But I wouldn't, and also remember that the Wards Cove case was followed by the 1991 Civil Rights Act, which ostensibly many people, what was supposed to, it aimed to, it was supposed to restore some of the criteria of disparate impact to civil rights law, but it did not restore the most important elements, at least from the kind of perspective that we were developing that would matter. It did tinker around with it. So, but again, Wards Cove is just a symbolically significant moment in a larger set of developments about the backlash against civil rights law. and clearly the backlash against the civil rights movement and a racial backlash and a class backlash that had begun in the 1970s, escalated dramatically during the 1980s, the Reagan administration, and really hasn't looked back very much at all. I mean, the Clinton era, Clinton just took it further in some ways. Obama did some tiny little things, but didn't really reverse very much. And of course, in the recent years, we've seen a dramatic escalation. So it was a moment. But it was a moment that deflated a lot of activists for a lot of causes, race and gender causes. And that's when I first became aware of it. By talking to all these civil rights lawyers for women, they say, well, there's nothing we can do anymore. We're not going to file any more lawsuits because there's no chance. And that was right, just before and right after Wards Cove. So it was significant in that regard.
Great, thank you. We have another request to speak. Mary Crest Castro from has requested to speak. I'm going to enable you now.
Hi, can you hear me okay?
Yes.
All right, awesome. I just really quickly wanted to just say thank you so much from the bottom of my heart. I'm actually an indigenous member of the Philippine tribe called the Agta Tabangnon. And, just the first book that I read on pre-colonial history was also written by a Michael, by the way, by Michael Scott, not you. But I just want to say that it's just very encouraging to just see this type of dialogue and this type of incredible groundbreaking work being done within our community in collaboration throughout different races and throughout different, worldviews and perspectives. And it's just amazing to see it come to fruition. I just wanted to say I'm very excited to read this book by another Michael. So, and of course, George, so thank you so much for your tireless efforts for the truth and to preserving the truth so that we might learn more about what justice looks like and what it can accomplish despite the entrenchment of systemic injustice happening within my country, the Philippines, and happening within our country in the United States of America. So I just wanted to just say thank you again to both of you and to your incredible efforts. And from the panel, thank you so much. It's an honor to hear Nemesio speak. I was actually crying earlier listening to you speak because it just shows to us how not that long ago this was, and how we have so much work to do as kind of this younger generation to pass on the truth. So thank you.
Thank you.
Great, thank you. We're about near the end of the event. We're at 6:59. I don't know if they want any final thoughts. Michael, there was an email that we were sent prior to the event that had a question too. If you'd like to respond to that, Michael.
Yeah, I think this from Mr. Duncan, that's going to be a long answer. It's about how we interpret the Supreme Court decision and the Ninth Circuit decision in Wards Cove. And I think that probably makes more sense because it'll be getting into the weeds of legality that we respond to Mr. Duncan separately in writing. I can do that tomorrow. But there's a key point there, and that is, there are lots of interpretations about what the Ninth Circuit did. And in fact, one of those, because the Ninth Circuit was split, there was a 3-judge panel who ruled one way, which was for the employers, and then a en banc decision, which basically ruled for the workers and for the arguments that they were making that disparate impact was a solid test and the subjective hiring policies could be dealt with under that. And then the Supreme Court stepped in and basically ruled against the en banc ruling by the Ninth Circuit. So one can get into a lot of that, and we can certainly know the legal scholarship people divide to some degree, although I think that the bulk of legal scholarship's on our side. But the key point is that our primary mission was not to work from within the standard existing case law. It was really to try and understand the disparate impact test and the reconstruction of the disparate impact test from a human rights perspective that was being waged as a challenge. And that's a different kind of standard. Again, this goes to Nemesio's sort of point is that, well, if your lawyers say I won, therefore I was right. Well, I don't think that the people we're writing about would say that. And we're trying to give them voice about changing law, not about how do you win within the existing law. But we'll write something up to Mr. Duncan. It's a very good set of questions, and it could make for a good argument, but I think it's a little bit beyond what we can do here for a large audience. It's, at least some people are still with us.
Great. Well, Michael and George, thank you so much for giving us your time, and to our panelists who joined us this evening. For everyone in the audience who's calling in from all over the world, we thank you so much for joining us. Quick pitch for the book. If you want to save some money on a purchase of the book, it's available for 20% off until February 18th on the University of Chicago Press website. But you have to have the special promo code, which is available in the chat transcript. I posted it there. If you don't get that and you'd like me to, and you want to follow up and get that from me by email, that's fine. Just visit the Bridges Center's website to get my contact. Thank you all very much. I'm going to leave Michael and George. Do you want to say any last words before we sign off this evening?
Just thanks again to the Bridges Center, to the panelists, to all our friends who've contributed to this, and as well as the criticisms, as well as the support, and to the very large audience that showed up to listen to this. We really appreciate it. It's quite humbling and quite encouraging.
Yeah, thanks. And if we didn't get to your question, feel free to reach out and contact us. Our emails are on the UW Political Science website. We'd be happy to hear from people.
Absolutely. 25 years working on this. I'm happy to extend it another few weeks. Thanks again to everybody.
All right. Thank you, everyone. Have a good night.
Take care. Good night.